Today I will be discussing the case of Garis and Neville Pidler in relation to the fair dealing for research or study exception. There were two applicants, Garis and Moore. Garis was a university lecturer who was commissioned to write a book review for publication in the West Australian newspaper in 1988. Moore was a journalist employed by the Sydney Morning Herald as a state political correspondent, providing them with 3 articles for publication in the newspaper in 1987. The respondent Jeffress was a press clipping and news monitoring agency. They provided their clients with photocopies of requested subjects in exchange for a fee. Jeffress had sent photocopies of the Garis work and the Moore works to their subscribers. However, no express license had been obtained for this purpose by Jeffress. The respondent Jeffress was a press clipping and Garis and Moore brought proceedings against Jeffress for infringement of copyright. Jeffress defended its use of the works, stating it constituted a fair dealing under the Copyright Act. Jeffress argued the use of the works fell under Section 40 for the purpose of either research or study, Section 41 for criticism or review, or Section 42 reporting news. Jeffress argued the use of the works fell under Section 40. Today I will focus on Section 40 of the Copyright Act, the fair dealing exception for research or study. Today I will focus on Section 40 of the Copyright Act states, a fair dealing with a literary, dramatic, musical or artistic work, or with an adaptation of a literary, dramatic or musical work, for the purpose of research or study does not constitute an infringement of the copyright in the work. Section 40 of the Copyright Act states, a fair dealing with a literary, dramatic, musical or artistic work, or with an adaptation. In Garis and Neville Jeffress, the courts found that research is found to mean a diligent and systematic inquiry or investigation into a subject in order to discover facts or principles. In Garis and Neville Jeffress, the courts found that research is found. In this case, Justice Beaumont rejected Jeffress' argument on 2 grounds. The first, while Jeffress made a systematic inquiry to recover articles or newspaper clippings on a particular subject, it did this for purely commercial reasons. It was in the nature of an information audit and was not research. Nor was what Jeffress carried out study. He said, there was a difference between the process of gathering facts on the one hand and conducting a course of study or research on the other. In this case, Justice Beaumont rejected Jeffress' argument on 2 grounds. The first, while Jeffress made a systematic inquiry to recover articles or news. The second ground was that the relevant purpose must be that of the person who is making the copy. Even if its customers were engaged in research, Jeffress was not. The relevant purpose was that of Jeffress, not of the customer. The second ground was that the relevant purpose must be that of the person who is making the copy. It was held that Jeffress had not used Garis or Moore's work for research or study, and therefore Section 40 did not apply. The court granted injunctions to restrain infringement of the Garis work and the Moore's work. This case created an important precedent in Australia, as it determined that the exception in Section 40 of the Copyright Act only applies if the person who does the copying is the person who does the research or study, as one person cannot exercise a fair dealing exception on behalf of another person. Effectively, there cannot be a third party or intermediary to assist with the copying. This has resulted in quite a narrow judicial interpretation of the fair dealing exception for research or study in the Copyright Act. This case created an important precedent in Australia, as it determined that the exception in Section. This strict interpretation is not shared throughout the Commonwealth, however, as in the Canadian case of CCH Canadian Limited and Law Society of Upper Canada, the Supreme Court held that an organisation is permitted to make copies on behalf of other people in reliance on the fair dealing for research or study exception. They allowed the Law Society of Upper Canada to continue to provide request-based photocopying services of legal articles, statutes and decisions to students and others, despite CCH Canadian Limited, Carswell Thompson Professional Publishing and Canada Law Book Incorporated claims of copyright, thereby resulting in a much broader interpretation of fair dealing than in Australia.